Welcome to the Member Engagement Show, the podcast for association professionals, brought to you by Higher Logic. I'm your host, Kelly Whalen, and in each episode, we'll talk to guests whose expertise will help you gain new members, boost retention, and deepen member involvement, all goals that can transform your organization. I invite you to subscribe to the podcast so you don't miss an episode, and visit us at higherlogic.com/podcasts to catch the best of past episodes. Now, let's start the show. Welcome back to the Member Engagement Show. Joining me today on the podcast is Dorothy Deng, a partner at Whiteford Law. Dorothy is an experienced attorney representing nonprofit organizations and associations. She also has general business and diverse international experience. She's handled a variety of work, including corporate governance, intellectual property, copyright, social media, and privacy issues. I'm thrilled to have her on the show today so that we can learn a bit more about the intersections of AI use and copyright law. So welcome to the show, Dorothy. Can you tell listeners a little more about yourself and your work in your own words?
Thank you, Kelly, and thank you for the opportunity. I'm very happy to be here. And as Kelly introduced earlier, I am a partner with Whiteford Law, and I'm with our associations, nonprofits, and political organizations practice section. So I work with associations every day. And what we do is we are the outsourced legal department for associations. So all of my colleagues, we are familiar with association issues. But in addition to that, each individual or each attorney at our section, everybody has their own thing. And I would say my thing, just to give a little bit of a context for this audience, is a lot related to digital content. And naturally, copyright and now generative AI has evolved into one of the areas that I'm personally very interested in. And just to give a little bit of a history and going back to memory lane, when I graduated from law school and became a licensed attorney, that was the year 2007. And at the time, I remember in the office, there's a more seasoned litigator asking people who has a Facebook account, because I would like to look up one of the named defendants in the lawsuit, and I don't know what that is, but I've heard that people would put their information on Facebook. So I was able to look up that person. And of course, this is before the privacy settings and all good stuff, and everybody didn't really know. So you upload all of the photos your mothers tell you not to upload, etc. So throughout the years, social media type legal issues, website terms of use, DMCA takedowns for copyright infringement, the mailing list scam, selling your membership list, hotel room scams, and then in more recent years, privacy law, data privacy, the GDPR, and now AI. It's sort of an evolution of technology and evolution of my own experience as a user of technology that has led me to now being very fascinated by the intersection of more traditional copyright law and the evolving generative AI technology.
I love how often anyone who works with like digital work or social media, they sort of end up getting sucked into it in part because they use it. I've definitely had that experience in my own career as well, where someone says like, wait, is someone using one of these social media platforms? Like, can you tell me more about it? So that's so relatable that was also a kind of an entry point for you as well.
Yes.
Well, I know we're going to really dig into the AI use and copyright law, but to start us out, I wonder if you could walk through some fundamental copyright principles and maybe focus especially on those that you see relating to AI use.
Well, thank you very much for the question, because that is really the core of what I'm seeing a lot is the gap for technologists and people who are very passionate about technology and the attorney, right? There's a gap between, and where do I see the gap? I think conceptually, there are two principles that's very important that is embedded in copyright law. The first one, and we'll talk about it today, the first one is the human authorship requirement, and the second one is the fair use doctrine. And I think we should start from the human authorship requirement. And the legal authority that is giving all of this is really embedded in the U.S. Constitution. Specifically, if you recall that there are three branches of the government. That's a different episode, but today we'll talk about the Article 1, Section 8, Clause 8, which is the copyright clause. It gives the Congress the power to promote the progress of science and useful arts by securing for limited times, here's the keywords, to authors and inventors the exclusive right to their respective writings and discoveries. So the two keywords here are authors and writings. And the court has consistently held that authors equals to human creators and writings are human created works. And there has been some more known cases. Before AI, there's quite a known case that is the monkey selfie case, and the monkey's name is Naruto. And you can Google that. But what it was there's this wildlife photographer. His name is David Slater. He set up a camera in Indonesia as part of his work to capture the monkeys. And one of the monkey, later named Naruto, picked up the camera and then made a selfie of the monkey selfie. And then PETA filed a lawsuit on behalf of the monkey to advocate for the monkeys owning the copyright to the photograph of the selfie as the quote author. So it went on for litigation for many, many years, but ultimately the court decision is confirming the Constitution copyright clause that to be owning copyright, you must be a human. So in the context of AI, there's already a circuit court level ruling issued very, very recently, just this March. And in that case, the plaintiff's name is Thaler, and he's like a computer programmer of some sort. But anyways, he owns this creative machine. And the creative machine generated an image. And he attempted to register copyright registration for this image that is generated by the creative machine. So testing the human authorship element, specifically on the application, he put down as the author, the creative machine, but as the copyright claimant, he put down his own name. And the theory is this is a work made for hire, like an employee. Or if you hire a consultant and you hire them to do work on behalf of your organization. So he didn't claim that he's a co-author. He didn't claim that. He just put down that the creative machine is the author. So the Copyright Office refused to register, and he filed a lawsuit. And then again, the court affirmed that the human authorship requirement is fundamental. Therefore, if you are only going to have the AI, quote, create content, that is not subject to copyrightability. And for further illustration and very detailed guidance about this human authorship component, I would strongly encourage the listener to check out the Copyright Office's report on AI. There's a 3-part report in terms of the human authorship requirement that is very much analyzed in part 2 of the report, is copyrightability. So we can get into that more, and we can get into more about the prompts and the output, etc. But human authorship is one of the fundamental principles.
That is so fascinating, because now that AI, and especially I think tools like ChatGPT, people kind of just have it as part of their workflow. And like even myself, I have it as part of my workflow when I'm drafting things or analyzing data and stuff like that. And it does call into question then what protections my organization would have if we feel that we own that content that I generate. But if I've used AI for a significant portion of creating that, it feels like it gets very muddy.
Yes. So it is, I think, one of the things that is very important. And again, check out the Copyright Office Part 2 report. But the conclusion, or just in very short summary, is the prompts for now, no matter how detailed your prompt is, it generally does not provide enough human control to make the user the author of the output. And also, this is also in the Copyright Office's report. When you are revising your prompt over and over again, you're just prompting, you're multiple times, you're revising it without anything more, it is like re-rolling a dice. You still don't have control. So the key is how much of a human control that requires the human creativity that is in the output. So there are a few things you can do. So the analysis really, there's, as we all, if you are a user of generated AI, we all know that there is a prompt, and then the AI algorithm generates, and then there's an output. So there's an input and there's an output. With respect to the output, the Copyright Office made it very clear that if you are rearranging, coordinating, or editing or modifying the output, and there's sufficient human expression in the sort of editing, rearrangement, and enhancing and adding in more creative elements to the output, then if it triggers sort of just de minimis authorship, then that will be subject to copyright because you're contributing your human contribution to that output. So you really want to add more to the output. And also there's other issues such as accuracy and ethical use, right? But for copyright purpose, just thinking about copyright, you really have an incentive to do more to the output. So there's one. The second concept is with respect to your prompt. As we all know, when we prompt things now, a lot of times you're drawing from your existing copyrighted materials, be it an image, be it an existing publication that maybe your association owns, and it's almost like creating derivative work. So in the Copyright Office's report, it uses a very good illustration of an image that is hand-drawn by an artist. So the artist sketch out an image, and it's a cyborg woman having roses coming out of her head. So that is hand-painted. And then the artist uploaded that image, and it's a very specific image, and again, you can check it out, but the prompt included, giving it cinematic lighting, giving it ultra hyper realism feel, and then that's the prompt. And then the output, you can see literally the outlines of the roses coming out of the woman's head, and with the facial kind of a profile feature of roses coming out. So this artist registered this image with the Copyright Office. In comparison to the creative machine that was solely indicated as author was a creative machine, in this case, the applicant, the claimant, the artist who draw the original sketch, she disclosed that she draw this picture, but this is the attempted registered work is a output that was through the creative generative AI tool. So the Copyright Office agreed to register that image, however, noting that the non-human expression is excluded. And if you check out that Copyright Office catalog, there is a note by the Copyright Office stating that registration is limited to the unaltered human pictorial authorship that is clearly perceptible and separable from the non-human expression that is excluded from the claim. So the Copyright Office excluded the AI-generated element, but nonetheless still agreed to register that work, which is a combination, and you can clearly see the outline of the hand-drawing sketch to the output. So it is possible, more likely, that if your prompt includes your pre-existing copyrighted human-created materials, and then the output, you can be perceptible, and you can see that, then it's more likely that you would own the copyright to the output as well. So there is an input analysis as well as an output analysis.
This is so fascinating to me because a lot of my work is generating content. So in addition to being interested for our listeners, I'm very interested on a personal level because it reminds me how important it is to, like, the best practice is already to have the human input, to not just be prompting AI and then just using it wholesale. And I think the way that I often hear it talked about is more in relation to the quality of what you get out of it. But this underscores to me that it's also in your best interest from a legal perspective to always have that human element. Maybe if I'm writing something, maybe I have an outline of what I want to write of a report or something like that. And maybe I do use ChatGPT to fill in some of the gaps, but that outline is from me. And similarly, if I were to prompt AI to give me something, then I would also heavily edit that, which currently I do anyway, because I'm just not a huge fan of how some things come out of ChatGPT and things like that. But it reinforces that that is worth doing, not just for a quality perspective, from like a protection of your own generated materials, I guess.
Right. So it makes me nervous when sometimes I see a label that AI generated. It's like you could be jeopardizing your ownership claim if you label that and it suggests it's purely AI generated, because again, purely AI generated, the copyrightability is really in question. Again, for now, the Copyright Office definitely recognize in their report over and over again that this report is based on the current technology and acknowledging the evolution. We are at the very beginning, so who knows? But at this moment, it's a black box.
Yeah.
The AI tool is a black box. Human does not have enough control. Regardless of how detailed your prompt is, you can never know for sure what's going to come out in the output.
Yeah. It strikes me too that, to your point about the kind of disclaimer on content that has included some AI generation, obviously in some ways that is ethically, maybe legally needed to clarify that you've used AI to generate something. But it sounds like it's very important to be clear how much and not necessarily say that something is entirely AI generated if there was human authorship as well.
So I do want to note one thing, because you drawed on that, which is the how much. So there's no percentage. It's really the question is how much of a human control, and it's the totality of your output and the totality of the effort. And again, whether or not it's perceptible of your pre-existing content, but there's no one fixed percentage, and which is when we get into fair use, it's similar. Like copyright law, surprisingly, a lot of the concept is it's the totality of the situation and not a specific percentage. And that's the same as human authorship. You can't say that, because I, have 35% that I can tell from my prompt. That's not how the current Copyright Office's position is when determining how much human authorship. So it is still the totality of the contribution and creative human contribution.
Yeah. So if you did end up in some kind of copyright litigation, there would be context involved in how they ruled on it. Yeah.
Yes. And it's also, you also spoke on, touch on one point is, especially if you are creating content that is high proprietary value, you may want to have at least some internal documentation to prove that it is a lot of human contribution and the AI tool is merely used to assist, like a spell check.
Yeah. Jumping off one thing you brought up. So I feel like we're talking right now about kind of like protecting the things that you create and copywriting and establishing your ownership of the things that you create if you are using AI to help you create it. But you also mentioned fair use doctrine. So switching gears a little bit, I'd love to hear a little bit more about when you are using AI, how do you protect yourself from copyright infringement? So when you're using AI, obviously some of these LLMs include a lot of copyrighted material that they didn't necessarily have permission to put into the models. And thus, when you're creating, you could feasibly be pulling from copyrighted material. What would you share about that side of it?
Well, thank you again. Thank you for the question. And I think we should start from what is fair use. So the fair use doctrine is a legal defense. What it means is it's not a matter of right. It's not a matter of law. It's available if you get sued in court. And it is codified in Section 107 of the Copyright Act. And you can go look it up. And the 4 elements are in the statute. And it is important to note that all of the litigation, copyright infringement litigation, when it gets to, if the defendant, again, another concept, it's a defense, meaning that the defendant would assert that as a defense after they are sued in court. And they need to put up evidence to support that I am fair using someone else's copyrighted materials. The burden of proof is on the defense side to prove and following the 4 elements. And when the judge issues a ruling, the judge's order would go through each element and analyze one by one, depending on the facts, on a case-by-case basis. So the first factor is the purpose and character of use. Second is the nature of the copyrighted work. Third is the amount of copyrighted work used. So is it 5 chapters out of 6 chapters, or is it 2 sentences out of, the entire book of 1,000 pages, right? So that's element number 3. Element number 4 is the effect of the use upon the potential market for the copyrighted work. Historically, element 1 and 4, especially number 4, has historically been the most important factor. But again, it's the totality of the 4 factors. In the context of generative AI, especially with respect to training the LLMs and just generally training the AI system, not as a user using it, but as the developers developing it and using that to train. Factor number 1 and factor number 4 has been the focus. And just to dive down deeper with factor number 1, what you are going to hear a lot, or if you're following news, is the transformativeness. Is using copyrighted work, such as books, musics, photographs, to train the LLMs for purposes of developing a generated AI tool, is that purpose transformative enough that it completely changes the purpose of the copyrighted work? That's very much of a focus. Then another very strong focus, again, consistent with how the court has been focusing on, which is number 4, the effect on the marketplace. And what it comes down to is their actual market substitution. And there are a few things that the court would consider. Is there any lost sales for the rights holder? Is there actual market dilution because of the generative AI copyrighted work flooding the market, diluting the market? Is there a lost licensing opportunity, etc.? Again, these are economic market consideration that the court's going to look into. So the Copyright Office also issued part 3 of its report that really gets into a lot of history and a lot of analysis and background and examples of fair use in its part 3. And note that part 3 is a pre-publication. It's not yet a publication. And 2 days after the pre-publication was issued, the head of the Copyright Office was fired by the administration. And the speculation is because the administration does not really like what the Copyright Office said in Part 3, which is the fair use doctrine, because of the tension between the tech developers, the technology sector, who really think that copyright, this fair use thing, is holding back the training, versus the content owners, such as the artists, the authors, the musicians. They said, no, you can't just use our copyrighted materials, right? So this is a ongoing effort, sort of an ongoing 2 sides philosophically. But so far, both the court and the Copyright Office position is the current fair use analysis continues to apply. So in the event of litigation, there's going to be a case-by-case analysis. And we have already seen there are 2 fair use orders that's been issued in two cases. One is against Meta, the other one is against Anthropic. And interestingly, these two cases have similar plaintiffs, which are authors, and they are pretty known. And ultimately, the court's position is going back to the four factors. Both judges agree that using copyrighted content to train LLMs is considered highly transformative. So highly favors fair use for factor number one. But with respect to factor number four, I think it's interesting that both judges noted that in both cases, the plaintiffs, which are the authors, they were unable to present any evidence of direct infringement. So they couldn't present any evidence that the output actually copied their book. And I want to point out, because I do think this is an important note, that both Meta and Anthropic, when they developed their LLM or whatever the algorithm and the AI system, they embedded guardrails to prevent infringement. And it's part of their product development effort. And in Meta, they call them adversarial prompting, which is someone would keep trying to make the output infringe the author's copyrighted books. But the system is coded in such a way that they just have mechanism in place, they call it guardrails in place, to prevent infringement from occurring, which all of these are noted in the judge's orders. In one of the cases, there's involving like a piracy library, so it's a secondary use, but limiting to just the training, both cases favor fair use would apply in the context of using copyrighted content to train the LLM. But note, I think it's very important to consider the group of plaintiffs here, because these are text, right? These are literature. I do think there's a stronger argument, just in my opinion, that if you are an artist, before generative AI, if you're not a famous artist, you're sort of like, I'm an artist and I get hired to do illustration for some books. Now, some of the potential clients are just going to start prompting their own illustration, and I'm going to lose my market. Similarly to musicians, right? Taylor Swift is not going to be impacted. But if you are starting up, like, doing coffee shop gigs and trying to be background music and things like that, it's like you may lose your potential client base if someone just wants to hire a not Taylor Swift, right? Just singing in the background. Well, now the market is going to be flooded. And as we know, if you just have AI generated without even human contribution, it's in the public domain. You don't have copyright, right? So people can just have like all these AI generated, not as high quality and less creative content out there and free to use. So if you're in that market and if you're not Taylor Swift, you may be losing business. So there's a lot of cases still going on. And also another thing to note is there's other type of plaintiffs, such as the New York Times. So in this case, both judges noted that whatever the output is, they're not competing with you. You did not present any evidence of loss of book sales. You're still the bestseller, right? You couldn't present any evidence on the market that whatever the output is competing with your book. However, if you think about a news outlet such as the New York Times, the value of their output and the value, it's different from like a J.K. Rowling, right? It's not the same, because of a news outlet, their value is to report on news.
And probably to drive like some web traffic. Like if they have web articles, they want you to come to their website because they're probably selling ad space and they make some money off of people coming to visit. So if someone's like searching and finding answers to news questions in an LLM instead of going to the New York Times website, then that could have a business impact.
Exactly. So it's a case-by-case analysis, and we have multiple active cases that are not fictional and not non-fictional authors, right? Artists is going to be a different analysis. The musician's going to be a different analysis, and New York Times is going to be a different analysis. So the takeaway here is do not take fair use as granted. And it is case by case, always case by case for now. There's no blanket fair use. There's no blanket non-infringement.
Yeah.
Therefore costing someone's job at the Copyright Office. So I think that's the takeaway I want to make sure.
From that takeaway, I guess I would ask then, what do you see as being some of the practical considerations for people who work with associations and nonprofit, for our listeners? Like, how should they be thinking about using AI with copyright in mind?
That's a great question, because that's a question all of the clients or all of the listeners are going to be wondering. And I did receive some questions from the audience when I presented at ASAE. So one of the takeaway is if you are, for example, if you're hiring a consultant to create work for you as an independent contractor or expert, subject matter expert, or writing a test exam item bank, right? Authors, that type of thing, I would suggest that the warranty clause be very clear that they're doing whatever they're supposed to do. And if your organization, you really want to put restrictions on how the content creator is using AI, it would be advisable to put that in the contract so it's clear. But ultimately, you want to make sure whoever you hire, they warrant to you, at least in the contract, that they are going to have sufficient human judgment and human contribution to it. I know that some people may want to have a restriction on using any AI. I don't know how practical it is these days, but if you do, that's where you want to put it in, is to have that in a contract provision. Another thing is just if your job is to create content for your association, just really you should not be lazy. You really should make sure there is sufficient human contribution to the output, especially for high proprietary content. It's one thing that you are doing a business email to internal colleague and it's not going to be publicized. But if you're going to publicize a white paper, a research, something official that's going to be published under your brand, and if you want to sell it on the market, you do want to make sure not only the accuracy, because you still can't trust the AI output 100%, but you need to make sure there's enough enhancement, modification, rearrangement, etc., to make sure you can confidently claim that there's sufficient human contribution to the content. I think that is very important. And another thing is, of course, depending on which AI tool maybe your company wants to use, you want to check the terms and conditions of your license with that tool to make sure. But generally, with respect to copyright, most of the terms, at least the terms I've used, regardless of enterprise or personal license, they, meaning the developers, they would grant the output ownership to you. So they don't want to be responsible for the output. It's it's on you. So I think that's less of an issue. I think more of the concern is whether or not these developer will use your input to train their system. And if you really care about that, I do think for enterprise licenses, some of them would allow you to opt out. Not even enterprise, they usually would promise you that they don't do it. But even for personal use, you have the option to opt out of training. I haven't done it myself, so I don't really know the details, but you can follow the instructions to try to opt out of having your input being part of training the platform that you're using.
A lot of what you just said really aligns with themes that I've heard overall anyway. Like Amanda DeLuke, who's one of our security and privacy people at Higher Logic, she and I did a webinar with ASAE earlier this year. And a lot of what you're describing is what we talked about for data privacy too, that you want to think about the ways that you're using it. You want to think about the vendors that you're using and make sure that you understand their rules and how they've set it up and how you're protected. It strikes me this might be a reason to maybe not build your own AI either, because well, kind of, you'd have to consider the risks and benefits of building your own AI because yes, you have more control over how it's built. But if you're doing it if you're not an expert in it and you don't put those guardrails that you talked about, like Meta and Anthropic having, where the guardrails say, do not directly quote an existing work without putting it in quotes, or just don't infringe on copyright, then you could get yourself into trouble in that regard. It also reminds me something I always think about personally, what you said about when you're creating content, don't be lazy. I have always felt like when someone asks me, where should you use AI and where maybe shouldn't you, that is a very important question to ask yourself and to have that conscious consideration in your mind of, should I use AI for this purpose? Is this an ethical use of AI? Is it a beneficial to my organization, or would it cause risks? Like, actually think about that before you're putting everything that you do into AI. Kind of ask yourself, what are the use cases, for example, maybe drafting an email, like you said, versus what are the uses where maybe I shouldn't do that? Like, I don't know. For me personally, there's a lot of bias in algorithms. And for me personally, I would never use AI to review resumes because I don't trust it. So I get that that's outside of the realm of copyright, but I just use it as an example of, ask yourself, what are the benefits of using AI? What are the risks of using AI in this specific use case that I would like to use it for?
I do have one point I want to make because it's an opportunity, and it may be something that some associations should also be considering, looking at it as an opportunity. So my understanding is, the reality is, if you are in the business of developing AI and training the algorithm or the learning mechanism, there's not enough data to train, right? We are, artificial intelligence, it's also going to level up. And in order to level up, they need better quality content and better quality data to train. So my understanding, again, learning from the technologists that I've been talking to, is AI is hungry to learn, right? And AI is hungry to consume energy. But again, that's a different conversation. But in terms of content, AI is hungry to be trained and using data. There's not enough data. So right now, to level up, AI needs expert level, the best quality data and content. All of the associations are expert in your field. So there is a licensing opportunity for very expertise, high level, high quality licensing materials just for purposes of training AI, depending on the use. So I think that's something that may not be copyright related, but it is relating to licensing and permission and considering opportunities there. Like you said, maybe we don't want to be the software engineers, but we can create data that is valuable and high quality that could potentially generate revenue for this new licensing market. And that's also mentioned in the Copyright Office's report, that there is an emerging licensing market for this type of data set that is highly technical and high quality, created for purposes. The purpose of creating these type of content is to train AI systems so the analytical skills for the AI can level up.
That is particularly fascinating. And I feel like that's where I always start to struggle, like following what the models will look like for that in the future. But at the same time, I think it goes back to a principle that some associations consider now anyway, which is considering what you have that is public and available on your website or just like publicly accessible versus what you have behind a paywall and that you have control over. I think that, in my mind at least, is the entry level to starting to consider, would I want to license some things to train models? Start out by considering, do you have too much of your stuff publicly that they're training on anyway? Like if you put it out in the internet, then, and it's not, for example, in an online community where you have control over what is yours and behind a paywall versus what is out just like on your website, now is the time to like ask yourself, well, where do we house our data and our information and our content? And are we thinking critically about where we put that so that it's not automatically training a model, or if maybe for the good of the industry, we want it to be out there. That's fine. I'm not saying everyone has to license everything, but I do think it's worth having those conversations and coming to it with an open-mindedness of trying to consider well, do we need to start having things, in an online community?
One last thing, because you mentioned that there is also another lawsuit filed by Reddit. It's based on the terms of use of violating terms of use. I think it's Anthropic is the defendant, but it's the Reddit lawsuit. So that's also recently filed, not on copyright basis, but on terms of use violation. So what you just said, there's going to be more to come in the courts on that legal basis.
Yeah. Is it sort of that Reddit didn't have permission to
Anthropic didn't have permission to use Reddit. So Reddit had, as we know, Reddit is a source
of a lot of information that goes into large language models. Yeah.
Right. I think it has something to do with users who deleted their Reddit account. And then I can't say I've studied the complaint, but know that it's out there, that it's not copyright, but on the terms of use, and it's Reddit. So I think that's enough. If you're trying to follow that, should get on your radar.
Oh, it just reminds me of when I worked at my organization, we dealt with when GDPR went into effect, and we had to start thinking about, okay, if someone contacts us and asks us to delete their data, how do we do that? And where do we have it all so that we know that when someone asks to delete it, that we actually have deleted it from everywhere? So that's very fascinating to me too. Right. And again, as much as obviously Reddit is a big, huge organization and they're going to have a little more weight potentially in a legal proceeding, these situations could happen for associations as well. You want to make sure that any member data, that you're very careful about where that exists and the ways that you protect it from just getting sucked into the black hole that is AI.
Right. And there's a technology component. It's because it begs the question, how did Reddit prevent that? Or is there a way to prevent that if I say I delete my Reddit account and Reddit promised me that nobody can access whatever I wrote, but now it appears, and I think
already
there's a way. Yeah, and some of the I know, for example, Perplexity, they would cite to Reddit for their sources sometimes. So I think it was probably in the case easier for Reddit to capture some kind of evidence as opposed to the authors that we talked about. They weren't able to present any evidence because the output couldn't do it. But for Reddit, perhaps it was cited specifically for a source from a user whose account was supposedly deleted, right? But something to watch, and I will certainly be monitoring any court ruling, etc., for that case, even though it's not copyright.
Yeah, still super interesting and has a lot of implications for the way that we all work in the world. I feel like we could probably talk about this topic for hours, but obviously you and I both have other responsibilities, and I don't know that people listen to hours-long podcast episodes. So is there anything else that you would call out that you feel like we haven't covered yet that you want listeners to think about?
I think we covered it. Resources are there. Check out the Copyright Office's AI report. It's very helpful. And the comparison of detailed prompt versus human contribution with a hand drawing artist, those are all, you can see it visually, they put it in the report. I find it to be very helpful for me to understand how the output and input sort of interacts to be copyrightable. So I would encourage you to read it. And then with the pre-publication part 3, again, it can be a conversation, right, about the recent affairs of the administration's position and the struggle with fundamental copyright law regime as it is currently. It's available out there, and I think there's more to come.
I can only imagine. I'm sure this is going to be a big area of litigation and where we're going to learn a lot. And I guess one thing I would say for listeners, just as someone, I am not obviously a lawyer, And so I think about when I've worked at small organizations, and this kind of thing can feel really overwhelming because it's so big and you might not have an on-staff legal person. Obviously, if you need help, you should seek legal counsel. But additionally, I think one of the initial things that organizations, even small organizations, can do is just be having these conversations. So asking what your internal data privacy practices are, discussing which tools, AI tools you're using and how you're using them and what types of data you're putting into them, and just kind of always discussing this. I know one of my organizations that I worked with, we would have periodically someone would bring an article to discuss with the team as part of our weekly team meetings. And this would have been something that we would maybe bring one of the articles about some of the legal cases that are in progress and discuss what that might mean and how we should consider our own content or our own data in the context of what we're seeing happen with these bigger organizations. Yeah.
Well said.
Well, thank you so much for coming on the show, Dorothy. This has been really fascinating for me personally, and I hope our listeners have taken away some things that they can keep in mind.
Thank you. Thank you for having me.